Hi everyone and welcome to Lawpolitan. Today we are diving into one of the most talked about constitutional showdowns, the Supreme Court's ruling on Tamil Nadu governor's delay in approving bills passed by the state legislature. Let's break it down. Between 2020 and 2023, the Tamil Nadu Legislative Assembly passed 12 bills related to state universities. Along with this, several proposals were sent to the governor's office. But most of these files were just left pending by the governor. No approvals, no rejection, just silence. Frustrated with the deadlock, the Tamil Nadu government knocked on the doors of the Supreme Court on 31st of October 2023. On 10th November, the Supreme Court issued notices. On 13th November, Governor R.N. Ravi suddenly withheld assent to 10 of these 12 bills and reserved 2 bills for the president. Owing to this, on November 18th, the Tamil Nadu Assembly repassed the same 10 bills without any changes and sent it back to the governor. On 28th November, the governor again reserved them for president without acting on the advice of Council of Ministers. How did the governor do that? According to Article 20 of our Constitution, when a bill is passed by the state legislature, the governor has 4 options: give assent to the bills, withhold assent, return it to the legislature for reconsideration, reserve it for the president but only under special circumstances. However, no timeline has been given under the Constitution. Now fast forward to April 8th. The Supreme Court, in a historic judgment, ruled that governor had no discretion to simply veto these bills. The Supreme Court called out the indefinite delays and imposed strict timelines for governors going forward. Using its extraordinary powers under Article 142, the Supreme Court deemed the 10 bills withheld by the governor as having received assent. Basically, the Supreme Court said, enough is enough, let's move forward. Now, what was the aftermath? Explosive. The Vice President of India passed a statement saying that we have judges who will legislate, who will perform executive functions, who will act as super parliament and absolutely have no accountability because the law of the land does not apply to them, and went on to describe Article 142 of the Constitution as nuclear missile against democratic forces available to the judiciary 24/7. BJP MP Nishikant Dubey went so far as to blame Chief Justice Khanna for triggering civil wars. The Supreme Court refused to hold Dubey in contempt and stated that courts are not fragile flowers to wilt under such absurd statements. Invoking Article 143 of the Constitution, today the President of India has asked Supreme Court whether such timelines can be imposed on the governors. This case isn't just about Tamil Nadu. It is about the balance of powers between state governments, executive, and the central government, and the judiciary stepping in whenever this balance breaks. What do you think? Was the Supreme Court within its power in this case? Drop your thoughts in the comments and don't forget to like, share, and subscribe for more deep dives into India's political and legal dramas.